Thank you, Mr. Chair, members of the committee. As you said, my name is Robert Kelly. I'm here on behalf of Convention of States Action. We are a nationwide grassroots nonprofit organization with nearly 4 million supporters across the country, and we are here to advocate in favor of SJR 57. Many of those supporters are here in this room with you. They're going to be sharing their support of it from a personal level here, but I would like to just offer my expertise. I have studied this issue for the past 6 years. I have looked into the legal ramifications of the Article 5 convention process. I briefly want to explain to the committee the purpose of the Article 5 convention process, why it was put in the Constitution, and then address some of the concerns and some of the objections that have been raised, because I think there's a fundamental misunderstanding of how the Article 5 process works and the limitations that actually do exist, both in the Constitution and from the history of practice in this country on how an Article 5 convention would actually take place. First and most fundamentally, this piece of legislation is not about a particular policy position. This legislation is not about Republican or Democrat. This legislation is not about conservative or liberal. What this legislation is about is a much more fundamental question than what is our policy. It's about the question of who decides what that policy should be. And our founders would have said that was really the ultimate question. And according to our Constitution, it is we the people who decide. And in order to secure that, in order to secure the rights of the people, the founders divided power within our government. First, they divided it between the branches of the federal government, the judiciary, the legislative, and executive branches, such that each of those branches would have an incentive to take power away from the rest, so that each of those branches would check the others. In James Madison's words, such that ambition would counteract ambition. And according to James Madison, it's that checks and balances system that secures our rights. Bills of rights are parchment barriers, ultimately. Venezuela has a phenomenal Bill of Rights. It has a constitution that's over 50 pages long that guarantees you every right under the sun. And yet none of that means anything without the meaningful, substantive checks and balances in the system. And that's exactly what this legislation is about. The founders not only checked power, however, between the branches of the federal government, they checked power by balancing it between a federal government and the state governments. And sadly, that balance of power, which we call federalism, has largely been dead in America for the past 50 years. The states have not exercised a meaningful check on the federal government. The states have not pushed back against federal overreaches of power. And the result is we have a federal government that does too much in our country here today. And that's not something that's just my opinion. That's the opinion of 72% of the American people. And that opinion holds true. A majority of the American people believe the federal government is too large and does too much. That holds true regardless of whether they're Republican or Democrat, whether they're here in Wisconsin or out in California. That holds true across both political and geographic barriers. And what Article 5 of the Constitution was designed to do is to ensure that that balance of power remained in place. It gives Congress the ability to propose amendments, as has already been discussed. 2/3 of Congress can propose amendments to our Constitution, but it also gives 2/3 of the states the ability to propose amendments to our Constitution, because as our founders recognized when they were drafting the Constitution, Congress cannot be the only body that's allowed to propose amendments. If so, we're never going to get amendments that are going to restrain the power of the government. If Congress becomes the problem, who are you going to go to solve it if only Congress has the ability to propose amendments? That's what this provision was designed to do in the Constitution, and that's what this legislation is about. It's about having the states step up to the table, saying that they're no longer just going to be treated as regional agencies of the federal government, and that they're going to actually push back on the federal government's overreach of power. So with that, Mr. Chair, I'd like to go ahead and address some of the objections that have been raised by the committee here. First and most fundamentally, it's important to recognize the distinction between the Constitutional Convention of 1787 and what's being proposed here today. The Constitutional Convention of 1787 was obviously not called under Article 5 of the Constitution, seeing as how Article 5 of the Constitution did not exist yet. It was not called under the Articles of Confederation, because the Articles of Confederation made no such provision for any such convention. Instead, it was called under the reserved sovereign authority of the states. The states were completely sovereign at the time that our Constitution was adopted, and the Articles of Confederation recognized that. They had the power to write a new constitution. They had the power to create a new system of government. And that's ultimately what they did at the Constitutional Convention of 1787. That is not what this piece of legislation here does. And I dare say none of the sponsors would be behind it, and none of the states that have adopted this across the country would have adopted this legislation if that's what it did. Instead, what this legislation does is it uses Article 5 of the U.S. Constitution and follows the procedures laid out there to allow the states to exercise exactly the same power that Congress has. The the power to propose amendments. And that's what Article 5 says. It says, on the application of the legislatures of 2/3 of the several states, Congress shall call a convention, which shall propose amendments, which shall be valid as part of this Constitution when ratified by legislatures of 3/4 of the several states or by conventions in 3/4 thereof. Now, as Leg Counsel pointed out earlier, the process laid out in Article 5 requires Congress to call a convention. It says shall call a convention when applied by the legislatures of 2/3 of the several states. Congress has no option upon this subject. Now, it's true we don't have a Supreme Court decision that says shall mean must. There's no Supreme Court interpretation interpreting that provision in Article 5, but it's clear enough from the drafting of the Constitution, right? Shall means must. Congress shall call a convention. Congress must call a convention when 2/3 of the several states apply. What is the purpose of that convention? Article 5 says the purpose of that convention is to propose amendments, and that's critically important. This convention has no power to ratify amendments. It has no power to rewrite our Constitution. It has the power, exactly the same power that Congress has, to propose amendments to our system of government. It's essentially a glorified drafting committee. Its provisions, any amendments that it drafts, have to go back to the states in order to be ratified, just as any proposals of Congress have to go back to the states to be ratified. And those provisions, those proposed amendments, must be ratified by 3/4 of the states. 38 states in our present system of government. And in fact, if you look at it from a state legislative body level, there are 99 state legislative bodies in the country. That means that 13 of those 99 bodies could stop any amendment proposal. In practical political terms, this means you need both Republicans and Democrats to back any such proposal. It means you're going to need to enjoy the overwhelming support of the American people behind any amendment proposal before it can become part of our Constitution. And that's exactly as our founders intended it. They pledged their honor, their lives, and their sacred fortunes to the provision of this country, to the birth of this country, and to the creation of our Constitution, and they did not make it easy to change that Constitution. Now, it's been raised on several occasions, well, this application seems very broad. It says limit the power and jurisdiction of the federal government. That seems to leave a lot on the table. And the answer is it does leave a lot on the table because there are a lot of abuses of power by our federal government. There are abuses of power by the federal judiciary. So we have to leave Article 3 open to amendment. There are abuses of power by the president. So we have to leave Article 2 open to amendment. There are abuses of power by Congress. So we need to leave Article 1 open to amendment. This application is intentionally drafted to allow the states to come together and draft proposals that address all of the overreach by the federal government, to debate and discuss and to come to agreement over how we can impose structural restraints on the federal government. There is, however, an important limitation in that language. It says limit the power of the federal government, limit the power and jurisdiction of the federal government. There is a directional limitation, which is absolutely critical. It would be absolutely inappropriate, and it would be outside the scope of this application for the legislatures, for a convention, to propose amendments that expanded the scope of the federal government. So, for example, taking away our Second Amendment rights, that would expand the scope of the federal government. That would not be limiting the power of the federal government, and therefore it would be outside the scope of this application. Taking away the 15th Amendment or the 19th Amendment or any of the Bill of Rights or any of the constitutional provisions that secure rights to the American people would be absolutely unconstitutional under this piece of legislation and would be struck down as such by the courts.